Hello, everyone. Welcome to LexTalk, world's talk show presented by Clickaway Creators. Today, we have Mr. Akshay Lal with us. Mr. Lal possesses over a decade of rich exposure in a wide range of legal affairs, including litigation, non-litigation matters, and arbitrations, and risk analysis, compliance, mitigation, legal drafting and documentation, and so on and so forth. His career journey has showcased excellence in managing pan India cases under various laws. We'll discuss about all those things. But without further ado, let me first of all introduce you to the man himself. Hello, Mr. Lal. Welcome to the show. And how are you doing today?
I'm doing good. Thank you. Thanks for the warm welcome.
It is all mine, sir. Thank you very much for getting some time out of busy schedule. And as you can see, I try to pick things out of your journey, but really it's not just possible for me. So I want you to uh, sort of give us a small journey to your profile. How did you end up from being into compliance and I mean the corporates to government? How does that journey went for you?
Yeah, like since the beginning of my law career, I always wanted to learn and grow as an individual in my profession to the best of my abilities. So when I started from a compliance setup, it very like in a very initial stage, I got to know which I was not having a knowledge as a fresher. It gave me a knowledge of legal laws applicable around the globe, which are usually not taught in a law school. So those things of like the experience of around 2 years plus gave me a very wide horizon and gave me a very good level of knowledge in the world of compliances. See, the laws are of so many types, from a small industry to a big company, or a very small company itself. There are a number of compliances laws are applicable to them, which are not they are not also aware about it. So the applicability part of of those compliances, we used to have a brainstorming during our those days. So it gave me a very good insight. So I started with a compliance setup, and that experience of compliance is like helping me a lot as a profession till today. And I worked for around 2 years plus, as just said. And thereafter, I got an opportunity to work in an in-house corporate setup. From compliance, I entered into an in-house setup where I worked for the company's corporates in their in-house legal teams. I brought my expertise of compliance along with litigation and arbitration, and supported to the best of my abilities to their teams. And thereafter, when I was working with in-house, we used to have a very many court cases litigation with a government setup also. So I got an opportunity to work with a government setup in a like technology development board. The organization name was, wherein I was working as a law officer, and there I utilized my expertise of market, of corporate legal department in the market. Like when I say the word market, I was bringing my experience of market in a pure government setup, which the government officers are not aware of, the procedural aspects and all. And there in the pure in-house in the pure government setup, I got my experience of compliances, which compliances are have to be abided by, which are the mandatory, which are the not mandatory compliances, which they should take care of. So for the government, I worked for around 3 years in my previous assignment. Then in this present profile where I'm working with the government as a consultant, I'm giving them my consultancy with the experience and knowledge which I'm bringing since last decade, a 10-year-old experience. So yes, in nutshell, if I sum up my journey, it has been a very adequate mix of many fruits, I would say, and my fruit basket of a profession, which I can bring before you, is this only.
That's great to hear, sir. That's great to hear, Mr. Lal. Thank you very much. Moving forward in the session, Um, I understand that every case is complex for a lawyer, whether it's an in-house lawyer or a litigation or any other thing. But my question actually is actually ironically different to that. Tell us about a complex legal issue you worked upon, or rather, interesting issue, and if you can describe the complexity around it and tell us how you really approached it.
I had a I was fortunate enough to work with a government board wherein there were many complexities and many complex cases I handled in my last previous assignment. Before that, also in my compliance domain wherein I was working, there were many aspects of uh, uh, which I would say were very complex in nature. What used to be the case, we were into a consulting domain, and we used to apply the applicable laws on our client who used to hire our services, and we used to have a negotiations, very complex form of negotiations, I would say argument with the law officers or the compliance officer of those companies. So I, in my initial stage of my career, when I was got an opportunity to have an opening meeting with my counterparts, there was some form of like scenarios, situations wherein there used to be a argument over applicability of certain laws. So there were a couple of situation like I will bring forth. I remember one occasion wherein I was having a discussion with our one of the manufacturing client of AC manufacturing industry company. So they were having their own plant or factory in Rajasthan state. So we were having a very complex argument on the part of applicability of Electricity Act and Atomic Energy Act on them. When we gave them the chalk of the list of applicable laws, they said that this particular provision of Electricity Act and Atomic Energy Regulatory Act is not applicable to us. And they were taking it in a very offensive way that how can you say that it is applicable? We were not abiding with this law. It was a gap on our part. How can you say that? So uh, to be honest, I was not successful in making them understand, but I did my best to make them understand the applicability of laws. Those laws were applicable to their industry, to their plant, to their factory, but they didn't agree to it. But that was a challenging part, making the applicability understand to already seasoned person, a senior person in legal industry. It was a task in itself, but later on they agreed to it and they abided also to those compliances which we gave them. So this was the initially challenging part of my career, which I just discussed. Thereafter, after like there were many small things which I won't be discussing right now due to the paucity of time. Uh, I in my previous venture where I was working with a board, uh, right amount when I joined that government board, insolvency and bankruptcy code was announced. It was passed by the Indian Parliament, and it became the law. So the previous uh, government board where I was working in there as the law officer, they were kind of working the mechanism. The business model was they were giving a loan for technology development in India. So they have given many loans to the startups, technology startups in India, and they were in the nature of financial creditor. Financial creditor has been defined under the IBC code. So we immediately took the all the defaulter industries companies who had defaulted in the repayment of loan under IBC code. One of the particular corporate debtor, they were kind of defaulting the loan since last many years, 10, 15 years, and they went into insolvency by another corporate financial creditors. They were the financial institutions. So immediately became the part of committee of creditors as defined under Insolvency Bankruptcy Code, and resolution professional was appointed. Thereafter, liquidator as per the procedure of the code. So the main challenging part now comes is the board, in its wisdom, did what? They converted their loan of one project given to that particular corporate debtor, the borrower, into a preference shares in one particular year of the loan tenure.
Mhm.
So now when we submitted our claim, as per IBC code, we have to submit our claim. The claim is what is owed to you by the corporate debtor. So when we submitted our claim to the insolvency, bankruptcy appointed liquidator and a resolution professional, the at the liquidation stage, the liquidator rejected our claim on the part that preference share won't form part of your claim. We
Mhm.
objected the decision of that liquidator before the adjudicating authorities, that was NCLT, National Company Law Tribunal, in the relevant bench, Calcutta,
Mhm.
and we won the case in that bench. The liquidator, towards that decision, went into appeal to NCLAT, National Company Law Appellate Tribunal,
Mhm.
wherein we again contested our best that our claim, the preference shares are forming part of that claim. Reason being that it's a law of the land. Whenever
Mhm.
there is an agreement states anything, agreement has to be abided by. So there was an agreement, and in agreement there was a condition to that agreement which shows that if there is a flout or any non-compliance on the part of a borrower, the conditions of the restructuring which was done will be waived off, and the original amount which was done in the principal agreement will have to be paid by the borrower, corporate debtor. So we
Mhm.
took the plea of that particular our agreement, debt restructuring agreement, wherein that condition was mentioned specifically, and we contested our case before the court. So it was a very hard won battle because the law of the land, as per Companies Act, is very clear. The preference shares won't are preference shares and the shareholding. Under the
Mhm.
shareholder, the preference shares are given the preference over the other shareholder till the point the company is into existence. But when the company doesn't exist, company has gone insolvent, thereafter it has gone into liquidation. How the preference shares claims can be taken, given a preference? That was the plea of the liquidator before the appellate tribunal also. But appellate tribunal favored our, like, they gave judgment on our side and said the agreement clearly states that if in the condition, if in a scenario they flout like any of the condition of the restructuring agreement, this
Mhm.
scheme of arrangement will be waived off, and the original principal agreement which was executed will have to be honored uh, by this corporate debtor. So court court said that in 2011 they may have converted their loan to a preference share, but it was very much stated that if they flout any of the repayment future schedules, this scheme of arrangement will be waived off, will be removed, will be scrapped. It will again go into original to a principal agreement. So court honored that particular agreement and said that liquidator are not supposed to adjudicate, decide unilaterally on their part. Liquidator has been given a power up to the point to decide and collate the claims of the parties, creditors. They are not deciding authorities over those claims. And that further ruled on our. So that was a big win to us because the claim amount was of crores and crores. So
Mhm.
that was the major thing issue.
That was really interesting, actually. Rather sharing two cases with us, because you have been on on, I guess, both the sides, I mean, litigation and non-litigation,
Yes,
and the
yes,
corporates, of course.
yes.
What I want to ask you is, how would you rate the current legal system's drive towards encouraging access to justice? And is there a gap? And if there is there a tangible movement in closing that justice gap?
Well, it's a very subjective question, I would say, and it require a very great amount of research on this topic. But as per my limited experience of 10 years, I can say justice has been the access to justice has been very simplified in today's scenario, I would say. If we go back before 2020, 2010, the a normal man, suppose in a very simple legislation like Consumer Protection Act, they were afraid of going to a consumer forum because they were not sure whether the consumer forum will accept their complaint or not, whether they will be getting any relief or not, whether they will be getting any kind of justice there or not. There was no movement, there was no scope, or there was no hope on the mind of a normal consumer. But nowadays, I've seen that people are getting so much justice friendly, I would say. They want so much justice. They immediately say that I will go to a consumer forum, I will sue you, uh, I will take you to a court of law. I have seen a very categorical shift since last 10, 15 years in the normal mindset of a layman, that at least if I am not getting immediate justice, at least there is a hope of a justice in near future, and I will be getting a relief, because there is so much accountability in today's government setup. There is so much system of checks and balance. There is so much, uh, like I would say, foolproof mechanism is there, which, like, I would say, uh, which regulates delivery of a justice in a efficient way, if not in a timely way. There is a saying also, justice delayed is justice denied. But I would say that line was applicable or suitable up till 15 years before. But in today's world, everything has been digitized. Courts are getting e-courts, and justice is getting so much swift, that and people, like, quality of lawyers is getting improved since last 10, 15 years, because of constant colleges, inter colleges, inter university moot court mechanism. So the final product, the law student coming out, it's getting so much worked up, so much intrigued in the system, I would say, that they are giving the good service to the society.
Hmm.
So access to justice, I would say, has definitely improved a lot.
That's good to hear, coming from someone who's as experienced as you are. Um, Also, I believe that within 10 years, you have seen a paradigm shift in terms of adapting the technology, the tools for to make the task go easy. And after pandemic, everything just pandemic basically worked as a catalyst in order to promote legal tech. And we are in the middle of the era of legal technology. My question actually is, what are the most commonly tools for you to make the task go easy?
So your question is basically to make task easy in the legal industry, right?
In the legal industry, what are those tools that you use? The legal tools that, like, like the Manupatra and the research tools and anything else.
Yeah, apart from the research tools were there in early 2000 also, but thereafter there have been many research tools apart from Manupatra, which helps in, like, researching legal cases, judgments, uh,
Mm.
rules and all, everything. But apart from that, there has been a very paradigm shift in the way legal compliance industry works.
Mhm.
Technology has very beautifully clubbed with our legal setup, and it has very, like, to the great extent, it has helped the legal industry in getting the uh, compliance regulated through our technology software tools. You must have learned about like heard about SaaS, software as a service. So many electronic legal compliance tools are there which helps you regulate your day-to-day compliances, PF, payroll compliances, and all. And we have gone 1 mile extra. So in last 5 years, we have integrated artificial intelligence to our legal compliance management, litigation compliance management. Uh, In-house legal counsels earlier used to like worry about what has happened in that matter, what was the order given, but now everything is coming by the click away. It's like order, daily judgments you can get on your systems. Earlier, it was a hell of a task because websites, courts servers were so slow, and if it is working, it was not uploaded in a timely manner. It used to like the physical labor which we used to undertake. We used to go to courts and take it manually. It was like hell of the task. But the technology in the aspects of compliances, how the contract, how the compliance, the technology has helped. Apart from the compliances, the contract management. Earlier, it was used to be a manual, a paperwork. People were contract like negotiating contracts on paper. There are many electronic compliances tools, sorry, electronic contract tools which helps you draft a contract electronically, and it reduces a lot of like human errors which might occur when we will do it through our human way, manual way. And see, and these are the two things. And third thing is taxation. Earlier, the taxation aspect of taxation laws were like everything was manual. I'm talking about taxation because at present I'm working with a taxation organization of India, GST taxation, GST network, one of the organization, which is a special purpose vehicle of government of India, amalgamating technology and GST regime together. Earlier, there was a officer Raj, used to be officer Raj. The officer at the field level, they were used to be having many power. They can reject a claim, they can reject the registration application, returns application of the taxpayer. But and they used to, there was a lot of corruption at the lower scale. But those things have been removed through a centralized portal. Now we pay our taxes through income tax portal. Now we pay our GST compliances, everything through a portal. So it has been possible through the use of technology. And technology, when clubbed with a law and policies, it is a very good, fruitful result, which I think it has been giving since last 10 years in several other segments also.
I mean, that's very rightly said. I mean, for our viewers, if you think where are those things, I mean, when it comes to clubbing technology and law, it's those things that we just mark and don't never read the T and Cs.
Yes,
But that is one of the irony. Uh, that's a great way, Mr. Lal. So far, this has been a great session, but I will not let you leave this session before I ask you our very signature question, which is because a lot of young professionals witness our show. So in that scenario, I want you to give them some nuggets. What can they do to make big in the industry? And also, if you can suggest them a time management mantra, because you see that's the most important part when it comes to legal.
well, there is no straight jacket or straight line formula for a success. In my decade-old experience, uh, the way I've evolved as an individual, there were many contributing factors to those things. Of course, there were my seniors who always guided me at many juncture at many levels. But one thing I kept on motivating myself was through constant reading. The habit of reading is there. It's very important for every legal professional. What happens in today's our legal education setup, the law school students are not they are usually being taught in a very theoretical way. That is, I can guarantee you, like 10 years before or 8 years before. But in today's setup, in today's, which I've observed, a lot of youngsters I have mentored in my day-to-day life. I have seen that they are getting a very theoretical education in a very beautiful way. A lot of good uh, theory classes they have been taking up on many education portals through their college also. But the one thing they lack is on the practical education, which they can imbibe, which they can undertake through a practical approach only. So the internship aspect, which I say, usually a law school student starts from third year in a 5 year law college. They usually start in a third year or fourth year. I would recommend them to start it from the first year itself. From your first year of the law college, start interning, start learning, intern for the sake of your knowledge, not for the sake of any stipend, any internship amount, and not or not, because that learning will take you very forward. Because for earning in a legal industry, you have got life to, because in a very funny way, we in a legal industry, we don't have any retirement age. We work till our brain works, as our one of the very renowned senior advocates said, I will work till my mind works. Mr. Ram Jetmani said. So start interning, start working from your first year of your law school. That will be my mool mantra. And secondly, keep on evolving, not to make yourself very precise or very stagnant to a particular area of law. Have a variety, because variety will take you upwards. It's I know many people will not agree to me to have a very expertise area of in a particular area of law, but I have never been an expert in particular area of law. I have been a generalist. I have a knowledge of each and every law to the best of my ability, but that is what makes me different from other. I can give advisory opinion to any person of each and every sphere of law, which is making me more demanding in market. So that is what I will advise. Second advice, to have a sphere of everything, to have a flavor of everything. If you have flavor of every area of law, that will take you much more ahead from other in the legal curve, I would say. So these were my two things which I would say to youngsters to take up their legal field ahead, the way they should take up.
I mean, that's really brilliant. I guess there are a lot of nuggets for uh, every one of us to take from this session. And I really enjoyed this session, Mr. Lal. Thank you very much for getting some time out of your schedule, as I mentioned earlier. And I hope you also enjoyed
Same
being on the
way,
show.
absolutely, absolutely.
Great to hear that as well. Then, and we of course look forward to having such great chat with you again in the future on some other trending topics in the international legal industry. Rather,
Sure,
thank you
sure.
very much for joining us, and yeah, stay in touch. We'll definitely have you in another session of Lex Talk. So, thank you very much, sir.
Thank you very much.
And for our viewers, if you like this chat, which I'm definitely sure that you did with Mr. Lal, I want you to like this video, to share this video, and click on that red button to subscribe to Click Away Creators YouTube channel to appreciate what we do. And you have more coming in from legal industry leaders like Mr. Akshay Lal. This was Sagar for Let's Talk World signing off.